Please rise. Justices of the Appellate Division, Supreme Court of the Department. PDE officers having business with the Appellate Division. Draw near, in your attendance, and shall be heard. Please be seated.
Good morning or good afternoon. Welcome to the Appellate Division First Department. We have almost 5 hours of argument time requested, so only ask for the time that you need. We have read your briefs and your papers, and we are familiar with the case. People versus Shavers. That is submitted. Rodriguez versus New York City Housing Authority. 3 minutes. Lodicio versus 520 Madison Owners. Appellate? Okay, that is submitted. People versus Cisneros is submitted. Bowden versus Tingling. I'm sorry. I didn't hear you. I'll give you 6 and 1 and 6. 160 East 84th Street versus New York State Division of Housing. I'm just surprised you're requesting 8 since it's the identical case, but I will give you 4 and 4. This case is the identical issue as to the case that's already been heard, right? Okay, 4 and 4. Fambro versus City of New York, which I know there are many parties here. Why don't we start with Lewis Foods? I'm sorry, what are you requesting? Affinita Curse. Philip Gaynor. Philip Gaynor's not here? Okay. The City of New York? Not here? Okay. Fambro?
That's me, Judge. I'll request 2 minutes.
And Gibbs? Gibbs is not here. Okay. Lewis Foods, I'll give 5 and 1. Affinita, I'll give 4 and 1. And Fambro, 2. Cabrera versus DirecTV, appellant. I'm sorry, 8 and 2.
Respondent requests 5 minutes.
6 and 1 and 5. Grenion versus Mid-Hudson Comprehensive. I am recused on that, but I will do the timing for it. Appellant? Are there 2 respondents? I'm sorry, how much time? I don't know why I'm having such trouble hearing everyone today. 6 and 1, 5 and 3. There are 2 Silvermans versus Silvermans, which we will hear together, so you should make the arguments as to both cases together. Appellant?
Appellant 8 and 2.
6 and 1 and 5. Nicholson versus Sabi Data, Sabi defendants. Plaintiff. 4 and 2. Atco. Select Safety.
5 minutes, please, Your Honor.
Okay, Sabi defendants will have 5 and 2, plaintiff will have 4 and 2, Atco will have 3, and Select Safety will have 5. Sky Coverage versus Alwex is submitted. Urban DC versus 29 Green Street is submitted. And Jayaram versus Jayaram is submitted. So the first case will be Rodriguez versus New York City Housing Authority.
Good afternoon, Your Honors. My name is Miriam Skolnick from Hertzfeld and Rubin, and I represent the Housing Authority. Just really came to make the point that the court below erred in finding that the garbage condition here could qualify as a recurrent condition. None of the elements necessary for a recurrent condition.
Didn't the witness admit that it was a recurring condition?
No, the witness said that there was garbage when he came in the morning, but he also said that he cleaned it every morning. First thing that he did was to clean the garbage, and that he cleaned it again before he left at the end of the day.
So it recurred, it just was routinely addressed, is what you're saying?
It was routinely addressed, and that's one of the elements that's necessary to change what's a general awareness into notice of a recurrent condition that the Court of Appeals found in Rivera, and this court has applied repeatedly. And that was
in this case here, the plaintiff had her tripped and fell before he had an opportunity to do his routine
right.
that he does.
Right. And there's the court, this court has recognized repeatedly that we're not required to patrol 24/7. I would just point out this was an outdoor location, and anyone could walk by and leave garbage there, and there was really no condition that we could have, no steps that we could have taken to prevent people from doing that. Unless the court has any questions.
Any further questions? Thank you very much.
Thank you very much.
Bowden versus Tingling.
May it please the court, Ned Hirschfeld for petitioner Monique Bowden. The error here is undisputed. Supreme Court denied attorneys' fees only by applying the wrong definition of prevailing party, one that excludes the catalyst theory. Once that error is fixed, the record convincingly shows that Ms. Bowden is entitled to fees as the catalyst in this case.
Counsel, even if we accept, which I think we should, that the catalyst theory is a law of the First Department, since that's been very clearly stated, why would it apply in this case? How have you shown and made your prima facie case that the bringing of the Article 78 was the catalyst for the judge issuing the decision?
Absolutely, Your Honor. So I'll run through the 3 steps that SOLA lays out. So step 1, Ms. Bowden received the full relief that her petition requested. That was an immediate decision on her objections under 439E, and that distinguishes this case from decisions the state cites like Gonzalez, where litigants had earned only
Let me ask you, though, because based on the timing, the Article 78 petition was filed at the court, and within hours, a 4-page decision was issued. Doesn't that suggest that the court was well onto its way on working and preparing and issuing the decision before that Article 78 was ever received?
So I'd like to answer that in 2 steps, if I could. One is to clarify the legal standard and then to apply it here. So the legal standard requires nothing more than that the petition hastened completion of the decision here.
Doesn't have to be the cause of it. You're using the word hasten. I'm not sure where hasten comes from.
So hasten comes from the state's own site to Citizens Cole, and we've added 2 more sites, Spencer and LaPointe, in our rebuttal. This is a bedrock feature of the catalyst theory, Your Honor. And so we believe that the record convincingly shows at minimum hastening, if not outright and full causation of the decision here. So begin with the chronology, which everyone agrees tends to be the best prima facie evidence in this type of case. Ms. Bowden filed objections that began by block quoting and bolding the 15-day deadline, just to make sure it wouldn't go missed. Even so, day 15 came and went with no decision. So did day 16, and every day in the week that followed that. And at that point, Ms. Bowden finally broke her silence, filed this Article 78 proceeding, and within a day, she had her decision. Now, that's exactly the type
Wasn't it the same day, though?
It was a day after it was filed and later.
Was
the
it
day
the
that
same day that was actually received by the court?
It was the same day that a paper copy was served. There's no evidence one way or the other about how soon respondent was aware after the filing. But even if we're dealing with the better part of a day, Your Honor, we believe that that is the type of close proximity that is particularly compelling
So
evidence.
do you think we should find that there's a prima facie showing that because the Article 78 was filed that day, and then she issued a 4-page decision a few hours later that day, that one hastened the other, and that she issued that decision more quickly because the Article 78 was received?
Yes, Your Honor, we think that's particularly appropriate on this record for 2 reasons. So the first is the scale, the small scale of the order that we're talking about. Now, these orders are very important to litigants concerned, and that's why we have this legislative 15-day deadline. But
Counsel, aren't you arguably setting up a situation where you're going to discourage the courts from issuing the decision too quickly then after the Article 78 is received? Because if they issue it the same day, then the petitioner will come and argue that it was the Article 78 that caused it, even if the decision is otherwise ready to go.
I don't believe so, Your Honor. So a couple points on that. The first is that we're not looking at a sort of an extreme case that one could imagine where, say, you have a petition filed and 5 minutes, 15 minutes, an hour later you have the decision. I think that would be a different set of facts, particularly if the scale of the order were larger than what we're dealing with here. So really specifically looking at the facts here, we have what is in fact a 3-page, not a 4-page, a 3-page order, the majority of which is procedural history recitation, 2 sentences of which are the legal analysis, finding no abuse of discretion. And again, there's nothing wrong with that. That's
Let me ask you this question. The question I have is that on February 6, 2019, the petitioner filed timely objections to the court order. So based on the analysis, based on the statute, the 15-day clock starts ticking at that point.
I don't believe it starts ticking at that point. I think you have to wait to see if there's a response from the other party.
Okay, so at what point did the 15-day expire then?
I believe it was March 14th was the.
That's when the 15-day expired.
Sorry, no,
March
I'm
14th.
sorry.
That's almost a month later.
That was wrong. I don't have the exact date in front of me, but it would.
Let's just say that let's just say that the respondent has rebuttal to the objection in 7 days, okay, in terms of responding to that. So you're looking at February 6th, 7 days later, February 13. So let's for argument's sake, the 15 days starts at that point, the clock starts running. So you're looking at the end of February in terms of the court ostensibly violating or not complying with the statute, correct?
So just to clarify, I believe the date is March 6th. That was
Okay, March 6th, right? So at that point, let's just say, let's take that it should have been issued at that point, a decision March 6th. Yet you waited till March 14th to almost a week later to commence the article. I mean, the argument is you really want to show the court didn't have this decision ready to go, you'd file it sooner than later, right? I mean, then we wouldn't be getting into this discussion of whether or not the simultaneous filing plus issuing of the decision hastened what decision, correct?
So I think it works the other way.
Did you follow that?
I think I understand your logic, but I would say that the reverse is actually true. So if we had a case where a litigant had waited until the very minute after, and I see my time has expired, if I could just finish my
You
answer.
could just finish answering the question.
If a litigant had waited till just the minute after a deadline expired to file, I think that would be the type of situation that this court should be wary of, where you would not have as strong a case of cause and effect, because it's completely conceivable that the decision was almost ready to go, and racing in the minute after the deadline.
That's a distinction without a difference. If you're looking to get a decision, it doesn't matter how fast. The faster you get it, the better you have it. I mean, you're just, okay, I hear what you're saying, but. Okay.
Your Honor, with respect, I would submit that the passage.
That wasn't really a question, but
Yeah, thank you.
Are there any more questions? Okay, thank you very much.
Thank you.
Good afternoon, Your Honors. Grace Dow for the state respondent. The court should affirm the dismissal of Bowden's Article 78 petition as moot and the denial of her request for attorney's fees under the State Equal Access to Justice Act. Just briefly to touch on the issue of mootness, the Court of Appeals has made clear that the exception to mootness should be invoked only to adjudicate questions not previously passed upon. Here, the only issue raised by Bowden's petition whether the 15-day deadline was mandatory was squarely addressed in the Liu case. Turning now to the issue of fees, putting aside the threshold question of whether the catalyst fee applies, and the state respectfully maintains for purposes of preservation that this court should join the other departments in rejecting that theory, the court still may affirm the denial of fees on two independent grounds. The first is that the state's position in this litigation was substantially justified. That standard focuses on the reasonableness of the state's position and not whether this court thinks that the state was ultimately right or wrong. And here, there was a 9-day delay in deciding Bowdoin's objections, and we respectfully submit that that delay does not defeat the state's substantial justification. As the Court of Appeals held in the Whitlinger case, delays do not automatically give rise to liability for attorney's fees. Instead, the test focuses on the circumstances, and here there is simply nothing in the record that shows the minimal week or so delay was motivated by bad faith or was intentional.
But doesn't the statute require the objections responded to within 15 days? And isn't that a sufficient basis?
Your Honor, in the Whitlinger case, the petitioner was also immediately entitled to the relief that he sought, which was the benefits. However,
let me just add something to that, which would maybe refine your response, because the case that we're really looking at is matter of lieu, where this court unambiguously held that you shall issue the decision within 15 days. So there's no question here that the decision was not issued in 15 days, which means the statute was violated.
Your Honor,
how does that affect that analysis?
We acknowledge that this court disagreed with the state's reading in matter of lieu, but the substantial justification test doesn't concern whether the state was ultimately right or wrong, but that at the time of the state's action, was it reasonable? And here there are two grounds for substantial justification. One is the minimal length of the delay, which was much shorter than the one that the Court of Appeals found to be substantially justified in Whitlinger. There was 47 days. And the second is that at the time that Bowdoin submitted her objections, this court had not yet issued the lieu decision. So that was not a binding precedent on the state.
But the statute speaks in mandatory terms.
Your Honor.
So I don't really accept that argument. The question I have is, was the family court aware of the petition?
Your Honor, the family court was served with a petition on March 15th, 2019.
So the same day, so you acknowledge that the same day that she released her decision.
Well, just to clarify the question, I'm sorry to add on, the judge as well as the family court.
There's nothing in the chronology in the record, Your Honor, is that the petition was served on family court at 2:33 p.m. on March 15th, and that a decision was sent to petitioner's counsel at, I believe, 3:53 p.m. That's the chronology that's in the case. And what we're saying is that that simply does not satisfy the prima facie case of causation that's necessary, even if this court were to apply the catalyst theory.
Is there any evidence in the record either way, whether the judge did or did not know about the Article 78, the particular judge who issued the decision, about whether she knew or did not know about the Article 78 petition when she issued her decision?
There's no evidence in the record, Your Honor, aside from the chronology, and it is petitioner's burden to show a prima facie case of causation. And we submit here that the chronology, the short amount of time, suggests instead that the state respondent had been working on the decision before the lawsuit was even filed.
So you're saying the circumstantial evidence is not sufficient to show that it was the Article 78 petition that catalyzed the issuance of the decision?
That's precisely right, Your Honor. And in fact, the circumstantial evidence would seem to cut against petitioner's argument, because there have been cases that have held that if there is a predisposition to achieve compliance or any efforts to provide the relief sought, that is sufficient to defeat an award of catalyst fees. And I'd refer the court to the Citizens Coalition case, which petitioner's counsel has mentioned at argument. In that case, the Sixth Circuit found that the defendant's predisposition to achieve compliance defeated an award of catalyst fees. And then the court said, and I quote, that the department may have moved more slowly than the coalition would have wished is beside the point. So expedition alone is not a grounds for awarding catalyst fees, even if there was any sort of causation here, which we submit petitioner has failed their burden to establish. Finally, Your Honor, I'd just like to mention that the circumstances here are particularly inapt for the catalyst theory to apply because family court ultimately denied Bowden's objections. This case is thus distinguishable from Liu, where the petitioner ultimately obtained a ruling in her favor and obtained the relief that she sought in her family court case. Here, the state respondent denied Bowden's objections, and the child support case against her was reinstated. Thus, viewed in the context of the overall litigation in this case, Bowden did not prevail in any meaningful sense, and that is why she is not entitled to an award of catalyst fees in this case, even if the court were to accept and to again apply that theory.
Thank you.
Thank you.
I'd like to quickly return to the question of whether we've made our prima facie case and make 4 quick
So the
points.
delay sounds like actually benefit your client, ultimately.
So if I could just get through these 4 points and then return to that, Your Honor.
I know, but can you just
Number
answer
one-
that?
No, you have to answer the
You
question.
gotta answer my
Yes,
question.
so number 1 is an answer to that, which is the Liu case also involved a similar delay of a few days, a week.
No, I just asked you for this case specifically, based on what the last point counsel made, is that this delay benefited your client, because ultimately, the child support that was reinstated against her.
No, Your Honor, delaying compliance with a mandatory deadline that was put in
You're not
place.
answering my question. I got it. Thank you. You can move, then you can go to your argument now.
Thank you, Your Honor. Point number 1, Liu involved a similar delay of a matter of days, a week or 2, between the deadline elapsing and Article 78 proceedings, so that should be no bar to a prima facie case here. Number 2, we have unique additional evidence that the same pattern has recurred in at least 3 recent family court adjudications, including the Porwick case, where there was the same one-day delay that undercuts any suggestion this was mere coincidence here.
You have
Number 3,
10 more
state-
seconds because your time's up.
10 seconds. The state has put no rebuttal evidence whatsoever in and has not, in its briefing, even ever disputed hastening. I believe I just heard counsel suggest that hastening is not the legal standard.
Okay, your time's up. Thanks. The next case is 160 East 84th Street versus New York Division of Housing.
May it please the court, my name is Jillian Bittner, and I represent the appellate landlord.
Let me jump right in because I was on the panel last week, not last week, previously, with this exact identical issue has already been decided. Why is there any reason that we would issue a different decision in this case than we did in that case? It's the same identical legal issue.
So, Your Honor, respectfully, the appellant submits that this court erred in
I
issuing.
know, but then you have to go to the Court of Appeals, right?
There is a motion to re-argue or for leave to the Court of Appeals pending that's returnable June 6th. And I just want to highlight a very important aspect of that motion. It's focused on the fact that the lease expiration, which was never a condition precedent, is what this court relied upon to interpret the application by DHER as prospective. However, it ignores the fact that the way that DHER's addenda apply the HSTPA is actually retroactive. It has to be retroactive.
But let's go back, and maybe this is part of the argument that happened a couple weeks ago. Were the 4 apartments at issue here, were they deregulated at the time the HSTPA went into effect?
The 4 apartments had orders that were final and binding.
Well, but that's not answering my question. Were the apartments deregulated on that date, or did other certain things have to occur, for example, expiration of leases, for deregulation to take effect?
The orders provide, and the statute provides, that the transition to the deregulated status does occur at the end of the lease.
So your answer to the question then is that the apartments were not deregulated at the time that the statute was passed?
The apartments did not have that status, but the lease expiration was not necessary for the orders of deregulation to be valid and
So
final.
in other words, you could have evicted the tenants as soon as he got the order, because the apartments were deregulated, or would you have to wait until the leases expire?
Actually, that's an interesting point that's brought up in the re-argument, and it's also emphasized in my reply. Former Rent Stabilization Law 26504.3E states that immediately upon receipt of the luxury deregulation order, the owner shall offer the current rent-stabilized tenant a fair market lease, and that the tenant has within 10 days to respond, after which the owner can commence an eviction proceeding.
So in other words, you don't have to, you don't have to follow the remainder of the lease, is that right?
In that situation, if the owner were to comply strictly with the statute, arguably no.
So, okay, so let's just, for hypothetical reasons, I'll grant you that argument. Was that done in any of these cases?
It was not done in these cases.
So then really, it's just a hypothetical then, right?
Well, there's two other bases that invalidate the point that the lease expiration is necessary for the deregulation, which are also raised in my reply brief in this instance and also in the motion to re-argue, which is that the 35-day window to challenge the validity of the order runs from the date the order of deregulation issued. It doesn't run from 35 days when the lease expired. Additionally, DHCR's policy provided for a cancellation clause, which, again, admittedly, it was not included in these leases, but the cancellation clause provided that an owner could put a rider with a lease when the renewal window came up while the luxury deregulation petition was pending. I see that my time has run out, and if the court has...
Does the bench have any more questions on this? Okay, thank you very much.
Thank you.
May it please the court, my name is Sandra Joseph for the respondent DHCR. As this court has said in 160 East 84th, 87 Cherry Street, and just last week in Hoy versus DHCR, the apartment 26504.3 provides that the statute that was repealed, that DHCR shall issue an order. The order shall state that the lease, that upon the expiration of the existing lease, the apartment will be deregulated. On June 14th, 2019, when HIPSA was enacted, these apartments were not deregulated. Despite the fact the orders were issued in 2018 and 2019, the leases did not expire in this case to 2030, 2019. The order gives the owner a prospective deregulation. On the date of the deregulation, on the date of the orders, it does not deregulate the apartment. If the court has no questions, I'll...
Thank you very much. I didn't do rebuttal, just because it's the same case that's been here a few times. And I know it's coming back again next week. Yes. Okay. Thank you. You have ample time next week to keep arguing the point. Fambro versus City of New York. And why don't we do Lewis Foods first, since that's who I...
Carmen Bourbon for defendant appellant Lewis Foods of Times Square. The lower court erred in denying Lewis Foods' summary judgment with regards to the claim of vicarious liability for assault and battery, negligent hiring and retention, and the negligence claim. The lower court found that there were issues of fact as to the authority and direction asserted by Lewis Foods via the store manager over the security guard, Kiersey.
Counselor, what control did Lewis Foods exercise over the security guard?
None. So Affinita is the security company, and they retain the responsibility to train, supervise, provide instruction and direction to its security guards. Lewis Foods had no duty or responsibilities.
Did Lewis Foods
Counsel,
have any?
didn't the manager, oh, I'm sorry.
She's asking a question.
I just want to ask you, no responsibility on Lewis Foods' part to train him, correct?
Correct.
No responsibility to supervise him, correct?
Wait, huh?
No responsibility to supervise, correct?
That's correct.
Okay.
However, the security guard was deployed to the scene by the manager who was working that overnight shift at McDonald's, correct?
Sorry, I didn't hear you.
The security guard, Mr. Kearse, came to the scene because he was directed to do so by the manager at the McDonald's, correct?
Yes, he motioned over the security guard to come over, and he pointed to the plaintiff, but there was no conversation between the store manager and the security guard. That altercation occurred within a few seconds from when the store manager had motioned over the security guard.
So in other words, the manager did not tell the security guard how to do his job. Is that
Correct.
And why should the negligent retention claim be dismissed?
So there's an agreement between Affinita, and that's the security company, and Lewis Foods, where Affinita agreed to provide security services in accordance with acceptable security standards and practices. Sorry.
Was there any notice that Mr. Kearse, the security guard, had done anything like this in a prior occasion?
No, so there was no complaints about that specific security guard in the past, and he didn't have any history regarding being involved in any fights prior to this incident.
Anything else you want to add?
No.
Okay, thank you very much.
Good afternoon. May it please the court. Patrick Lawless for the defendants' appellants, Affinita and Kearse. With respect to the malicious prosecution claim, the evidence shows that Mr. Kearse did not initiate any proceedings against the plaintiffs.
Well, counsel, let me ask you, wasn't the decision to arrest initially made because of Kearse's identification of them as the assailant? And if that was false at the time it was made, and we don't know that yet, isn't that a basis for a malicious prosecution claim?
No, it wasn't false. He was still struck with the napkin dispenser, and
Right, but he
bleeding
was saying that they were the initial assailant and he was just defending himself, which is why they were arrested. If that was not in fact true, that he was the initial assailant and they were just defending themselves, why wouldn't that support a claim? And we don't know the answer to that yet. Why wouldn't that support a claim for malicious prosecution?
Well, it wouldn't support a claim for malicious prosecution because the arresting officer, Officer Markgraf, testified that when he viewed the surveillance video footage, that it still did not...
That was after the fact.
I'm sorry?
Wasn't that after the fact? When did he view the surveillance?
It was after the fact, but it said...
It was after the fact. I mean, so what does that matter?
But he testified...
If your employee lied about who the primary aggressor was, and the police officer accepted that and then acted on that by making certain arrests, why can't a malicious prosecution lie?
Well, because Officer Markgraf said that his determination that the plaintiffs were the primary aggressors was not changed after viewing...
But that's an issue of fact for trial. Isn't that an ultimate issue for the jury to decide? It's not for the officer to decide who the primary aggressor was, because clearly your client threw something, and there's a question as to what the timing and sequencing was.
Well, but also, all Kearse told the officer was that he was struck in the head with a napkin dispenser, which was accurate. The fact that
Wait a second, I thought he didn't tell the court officer that he was struck in the head. He said, not by that, he said he was, I'm sorry, he didn't say that he threw the napkin dispenser, correct? He just
Correct.
said, I was knocked senseless, never said anything about him throwing a napkin dispenser, correct?
Correct.
Right.
But at the
So doesn't
time,
that raise an issue of fact as to who's the initial aggressor here?
again, based upon Officer Markgraf's testimony, that wouldn't have changed anything.
You're saying that as a matter of law, at the time when he says that, because the officer, again, reviewed the tape after the arrest, not before the arrest, correct?
Correct.
So how could that affect whether at the time of the arrest, your client falsely stated who started the altercation?
He didn't falsely say it, he just admitted that he
Well, I
threw
mean,
it.
good for
And at the
you,
ti-
thinking that you're appreciating your client, but isn't that for a jury to decide? Because certainly the other people involved in the altercation are saying something completely different, right?
But at the end of the day, he was still struck. He was, Kearse was still
Counsel, I
struck
think
and he was
my-
still
what my
assaulted.
colleague, counsel, what my colleague is suggesting is that maybe there was omissions by your client in terms of what happened and what his steps were, and maybe the police, had everything been told at that time, maybe the officer would have reacted differently. And isn't that an issue of fact, ultimately for trial, who the primary aggressor is?
Not when the officer said it wouldn't have changed anything.
Okay, thank you very much.
Thank you.
May it please the court, my name is Michael Braverman of Getz and Braverman, counsel for Respondent Famro. Good afternoon. Your Honors, I'm just going to ask that this court affirm the lower court's decision finding that there were issues of fact with respect to Mr. Famro's malicious prosecution false arrest claim. Specifically with false arrest, in this
Well,
case,
let's start with Lewis Foods.
yes.
What evidence do you have that Lewis Foods negligently supervised? What evidence do you submit that Lewis Foods negligently retained or supervised the security guard?
I think under the facts and circumstances of the
No, just let them list it up. What do you got?
all we have here is the manager directing the security guard to handle the situation.
That's all. Other than that, you have nothing, correct? He
I think
says
that-
to the security guard, look, what's happening. And on that, you want to support a negligent hiring, negligent supervision, failure to train, cause of action?
I believe that there are questions of fact whether his direction under those
I don't know how you can
circumstances.
support those three claims on the fact that he said, I mean,
I will
hear
rest on
you.
my brief. I will rest on my
I hear
brief.
you. Let's move on from Lewis.
Let's go back a minute, though, to the false arrest, which is what you
Yes.
started with. What did Lewis Foods do to support a false arrest? What did they do besides call 911? And is that enough to support a false arrest claim that they called 911?
No, we have no claim against Lewis Foods for the false arrest. It's against, I was mistaken in my brief. It is against Affinity and Curse. That's who we have the false arrest and malicious prosecution claim against. And in that case, look, simple scenario. The police show up, there's two versions of what happened. The police make an arrest. There's no video. And there's no false arrest claim because there's nothing to indicate.
I think we saw a video. It
No,
might
no,
have
we
been Not
did.
a good video.
We did, and that helps, and that's what I'm saying.
Yeah.
I see my time is up.
Yeah,
One
thank-
second. So in
No,
this,
it's okay. Thank you.
okay, thank you.
Lewis Foods? Okay. Then Finita?
And just very briefly, I didn't address the negligent hiring and assault claim.
Let me ask you that, because I know the court below conflated the two principles. Is there any evidence that they had knowledge of any propensity on the
Not-
part of the security?
No evidence in this record of any propensity of any prior similar conduct by Mr. Kearse. And also, it's our position that this, throwing a napkin dispenser would not be part of the scope of his employment as a security guard. It is so outside the scope, that Afanita can't be held liable for his actions.
That goes to, you're conflating that too. That goes to vicarious liability, it doesn't go to negligent retention.
No, it doesn't go to negligent hiring. So the only claim, the only real claim would be against Avenida would be the negligent hiring, and there's no prior.
There's also a
notice.
negligence claim against Affinita.
Yeah,
And that argument goes to that claim, obviously. Okay.
thank you.
Thank you very much. Okay, the next case is Cabrera versus DirecTV.
May it please the court, my name is William O'Connell from Goldberg Segala for the defendant appellants DirecTV and Mastech. Your Honors, we believe the lower court erred in granting the plaintiff's summary judgment motion on the Labor Law 240 claim and in also failing to dismiss the 241-6 claim based on the last code provision. It's obviously standard law for a prima facie showing labor law. We need a violation and we need proximate cause. In this instance, the plaintiff did not provide evidence of either one to meet their prima facie burden.
Is it, go ahead.
Go ahead.
Is it enough to know that it was a very windy day and that he fell from a ladder? Is that sufficient?
Is it enough
I'm
to
sorry,
know?
Let me add one more element to that, and there's in the record, there's photos of a broken ladder.
Yes, we're not disputing the ladder was broken.
Right, so isn't that sufficient to make?
No, it's not. It has to
Why
be
is that?
shown that the safety device was inadequate. And plaintiff in this case, when he testified at his deposition, all of a sudden seemed to not remember what happened from the time he was descending the ladder, and then all of a sudden he was on the ground and he saw a split ladder. So he had nothing to say in between that. And we all know on the defense side with the expert, there's a lot of other evidence saying what happened to this ladder.
Did he add more detail with his affidavit that filled in that lacuna?
He did add some detail to his affidavit, and it's my position that that's a feigned issue of fact. A feigned affidavit because he's trying to now say what he wouldn't say in his deposition in order to try to win summary judgment. I'd ask the court to disregard that. It's inconsistent. Go ahead.
Okay, fair enough. Some of the claims maybe, but how about with respect to his statement in the affidavit that he didn't slip or simply lose his balance, he fell because the ladder broke, and he also says that he didn't land on the ladder. Aren't those things that can be considered?
At first he testifies, I don't know, and now he's saying that I didn't slip and...
So in his deposition testimony, he testified more than once that he said he didn't know how he fell, correct?
Multiple times. I have it all in some in my brief, yes.
And then in his affidavit, he said something different, correct?
He did say something different. I'm not saying the court, I would disregard it. To me, it's inconsistent with what he said. He was asked point blank at a deposition, what happened here? And he said, I'm descending, and then all of a sudden I'm at the bottom.
So
And he
is it
said
your
that 2 or 3
position
times.
that at a minimum, you can't get summary judgment when there are he gives two different explanations?
Well, correct. There's obviously, in this case, to me, there's a sign when we have a ladder here. Just to go back, as you know from the record, that this was used for a year, plaintiff's own ladder, he purchased it, he used it 4 or 5 times on the morning of the accident, and he said it was fine, never had a problem with it before, and now all of a sudden, it just crumbles, allegedly, but he doesn't even testify.
Wait. What do you mean allegedly? There's a broken ladder.
Well, that it crumbles by itself because he's coming down. I apologize.
There's a broken
I'll
ladder.
be more accurate. He doesn't say what happened to it.
Did
He
the
just
plaintiff
says
put
that
in did the plaintiff, anybody look at the ladder and say this ladder broke because
No,
it
the plaintiff
was-
did not have anybody look at it. The plaintiff did not have an expert in this case. The
Because it
plaintiff did not
was
have
like
anybody who
something was
commented on
wrong?
the adequacy or causation, which are legal questions that really are beyond the competence of the plaintiff to testify, and certainly plaintiff's counsel to testify or to write in
Isn't
his
the fact,
papers.
though, that the ladder, he was going down it, and it broke enough to at least create a prima facie case of liability under the labor law?
Your Honor, if he had testified that he was going down the ladder and it broke, I would agree with you. He did
Well,
not.
there's evidence in the record, though, that he was going down the ladder, and there's evidence in the record that it broke.
There is both, and I've
So
already
why
argued
isn't that
why
enough?
I'm sorry?
Why isn't that enough for the prima facie?
Because I think you should disregard the second evidence where he says that it broke and that's why he fell. He did not say that at first under oath when he was asked repeatedly. So I don't think you have to accept that either in terms of a prima facie. But even if there is a prima facie, our expert clearly created a tribal issue of fact here. The court said it was speculative, and it wasn't. You just have to take a look at the affidavit. He discussed the wind. He discussed personal inspection. He discussed the micro hardness of the pieces, that it was not fatigue fracture, but it was a one-time impact load. And then something a little bit beyond me, I'm not a great...
So in other words, the ladder broke because plaintiff fell on it, but the plaintiff says that the ladder was not under him when he was on the ground. Isn't that sort of inconsistent with your theory? And does that mean that there's speculation by your expert as to his opinion?
Yeah, to be honest, Your Honor, I didn't really understand that argument in plaintiff's brief. It's my understanding from reading both sides that the expert's theory is that the plaintiff fell and as the ladder was standing and fractured it in half. So what somebody was lying under on the ground, I'm not really sure what that has to do with. To me, it's his position that something different happened here. The ladder was a good ladder, and that he fell off the ladder and he fractured it in half. And it's our position that the alleged inadequacy of the ladder did not proximately cause this accident. And our expert also said that it met all standards, so it wasn't even an inadequate ladder.
Okay, you'll have
That's
time
my
to reply.
time, and I'll defer to counsel. Thank you.
Good afternoon, Your Honors. May it please the court, my name is Michael Altman, the Altman Law Firm, appellate counsel for plaintiff respondent. I think your questioning and counsel's answers get to the heart of the matter, which is the only way their experts claim that the ladder did not break and cause the fall would be if the ladder was
But let me stop you there for a second.
Sure.
I read the deposition testimony of your client. Your client really is equivocal at best in terms of what occurred, because he doesn't really remember. The affidavit, hold on, the affidavit is a little more detailed, drafted by you presumably. Why should we consider the affidavit when we have his deposition testimony where he doesn't really pinpoint? He says maybe he heard a crack, but that's it. Doesn't really say much more than that.
Right, so I think if you look at his deposition testimony at 136 through 140, that's where he's speaking about what happened. He fell, the ladder broke, it cracked in half. This is somebody who fell, conked his head, was out for a few moments, so he does not recall exactly what happened.
So, counsel, why isn't there a disputed issue of fact whether he fell and broke the ladder versus the ladder broke and then he fell? How can we tell from this record which is the correct scenario based on what we have before us as a matter of law?
So I have two answers to that. The first is the concept the plaintiff fell from the ladder because it was windy, then the ladder fell under him and he fell on top of it, breaking it, which is what the expert claimed, just makes no sense. It's absurd. And I understand counsel came here and said his understanding is that the ladder was standing and Mr. Cabrera fell on it. So I'd just like to point to
No, you still didn't answer Justice Kern's question. There's two questions. What do you have in the record to show that the ladder broke when he's on it versus it broke after he fell?
Right, so that's what I'm saying, is that I believe his testimony...
So far, you've just said absurd, though. You haven't otherwise said... You said absurd, but then you haven't explained why it's absurd.
I'm listening intently.
Right, but that's what I was trying to get to. It's at page 367 of the record, at paragraph 41. The experts claim...
No, it's your client.
It's your motion.
Burden. What did you put in?
Right, so what I said...
What did you put in to show that the ladder was inadequate?
That the ladder was inadequate?
Yes.
Two sets of things. The first is the plaintiff was on it, climbing down and that the ladder broke and he fell.
Okay.
Wait a minute.
And wait,
So where did that's a conclusion. Show me where that, in your client's deposition testimony, he did not say that. He might have said that in the affidavit that you drafted, but he didn't say that in his deposition, right?
Right, so what
Will you
I'm saying
agree
is
with
that I believe
Is that
that,
true?
I believe that if.
I mean, he
that
was
when-
asked every which way, how did this happen? And he never said that.
Well, I don't think he was asked every which way, because he was never just asked the simple question, do you know what caused your fall?
Okay.
And I think at pages 136 through 140, when you're reading it, the gist is that he fell because the ladder broke.
No, he says to the question, did you hear something? He says, no, no, no. And then he says, did you hear? And then he says, well, maybe I heard a crack,
Right, he
but
said-
I'm not sure.
Right, he's
That
not
is
sure
very
whether he heard the
equivocal
crack.
from the case law that I hear or the case law that I read where the plaintiffs had testified during deposition, I heard a crack, I heard a pop. You've got an equivocal statement from your client during the deposition. You got anything else to tell us or at least show to us that that ladder cracked and broke while he was on it?
Again, all I can point to is his testimony and the fact that
I'm sorry.
Counsel, the trial court-
Tell me precisely where he says,
again, it's at 136 through 140 of the record where he talks about how he fell and that the ladder was broken. That's all there is.
Okay.
And I don't think anybody anticipated that somebody would come and claim anything else. But I think importantly, what I don't want.
Seriously, you said that? Okay, I got it.
But counsel, looking at that exact testimony, at page 139, I'm looking now, so that's part of the testimony you pointed us to.
Right.
The question was, but how do you know yourself if the ladder cracked? He answers, yes. Question, how do you know that? Answer, because I have the ladder and looked like it broke in half almost. So, question, so looking at the ladder after the fact, that it looks broken in half, that leads you to believe that the ladder did break to get you in that position, right? Yes. So he's saying, in other words, I'm on the ground, I'm looking at the ladder, and it's broken. So that's how I know it broke.
I'm sorry, I didn't hear the last thing you said, Your Honor.
The testimony, just summarized, is that I'm on the ground, I see the broken ladder, therefore I know the ladder broke, but he doesn't say when the ladder broke.
That would be correct. But there's the whole line of cases that he was working on an unsecured ladder that failed. And this concept that he was
but
blown
if the
off-
ladder, I'm sorry to interrupt you, but if the ladder broke after, when it was on the ground, would you still be entitled to summary judgment? So in other words, are you entitled to summary judgment under either scenario?
I believe we do, because if he fell and the ladder fell with him, this court's precedent establishes that he has demonstrated he wasn't provided with a ladder that remained erect and stood. That's the Ping Ling case.
Wait. You're saying if he fell and then the ladder fell?
No.
You would be entitled to summary judgment? Because that's what the defendant is saying, that he fell, then the ladder fell, and the ladder broke.
Well, again, but this is all based on their experts' claim.
And your client testified he didn't know how the accident happened,
But
right?
all their expert says is that the ladder broke when Mr. Cabrera fell on it.
Okay, right.
How do you fall on something that's not under you?
Thank you.
Thank you, Your Honor.
Your Honors, I'll be brief. My point here, I think we just have to go back and go to the original summary judgment principles, and did they meet their original burden to show that it was inadequate?
So can you address counsel's statement that your expert's view of how this ladder would have broke is absurd?
I read that in the brief, or silly or absurd. There was a few comments like that. To me, it actually makes perfect sense. He's saying that the plaintiff was coming down, it was a windy day, and that he fell, and that he hit the ladder and he broke it. The plaintiff himself, his body.
He was more than 200 pounds, right? He was
200 pounds, and that's how the ladder broke. So again, if you go back a little bit more clearly in some of the Second Department cases that suggest the inadequacy of the ladder has to cause the plaintiff's injuries, and that's not what happened here. at least under the defense theory's expert. And that's evidence in this case. It's not.
Counsel, let me ask you one last question.
Yes, sir.
Because Supreme Court relied on the case Hoxhadge. And in Hoxhadge, there was some wobbling of the ladder that the plaintiff was able to testify to. So like the ladder was wobbling and then it fell. Is there any testimony about wobbling pre-fall in this case?
Your Honor, that one word, is there testimony about what? I couldn't quite get it.
Whether there was any wobbling.
Oh, wobbling, no.
Yeah.
There's absolutely no testimony in this case, and that's the difference. You can show inadequacy easily if you can show the ladder moved or somehow it didn't perform as it's supposed to. In this case, previously and during the accident, there's no evidence that it didn't perform, and it's a defense theory that he fell on it and he broke it. And that, that's a tribal issue of fact in our view.
Thank you
Just
very
one
much.
last, I'm sorry,
No,
Judge.
your time's up. Thank you very much. The next case is Grenyon versus Mid-Hudson Comprehensive, and I am recused on that matter.
Okay, counsel. May begin.
May it please the court. Your Honors, good afternoon. Matthew Gammons on behalf of petitioner appellant. It's a medical malpractice case. Case is a failure to diagnose breast cancer.
I think we're aware of the case, Counselor.
But importantly, Judge, the main claim in the case parlays into the argument. The main claim in this case is that they failed to warn the plaintiff of the risk of what she's dealing with.
So why do you say that? Because my understanding of the record, unless I misread the record, is that your client had breast cancer and she had a mastectomy, right, before, several years beforehand.
Yes, sir.
Went to see the first doctor, Rao, because she worked with him. He did whatever he had to do the MRIs and everything. And then she went to go see Dr. Rigney, and he did some further tests and everything. And then ultimately, she ended up seeing Dr. Shapiro. With Dr. Shapiro, she gave her 3 referrals. She told her what to do. But from my understanding, the plaintiff made the appointments on the referrals and then canceled it because she didn't have health insurance. So where's the causation in all this, right?
Absolutely, Your Honor.
In terms of the delay of diagnosis.
Understood. Well, I start with the premise that no person, including this plaintiff, wants to die. She doesn't, if she knew she had cancer, if she knew cancer was a risk, knowing she had it before.
Okay, but really, yes.
Yeah.
We're all sympathetic to people who are ill. That's not an issue. The issue is she's given the scripts, she's told to get the appointments, and she doesn't go, as she testifies, because I didn't have health insurance. So how is that any of the doctor's responsibility?
Well, I think we're putting a little too much import on the health insurance. That was one.
Is that not really why she didn't?
No, I think that is the initial reason. I think that if she thought and believed she had cancer, particularly.
Did she testify to that?
Yes, of course she did, Your Honor.
She testified, if I knew I had cancer, I would have gone out and bought health insurance?
Not that. That wasn't out.
Well, tell
But
me
she-
what you think she testified, that if I knew
know
I
what
had
she-
cancer, I would have gone out and bought my health insurance.
So what she testified to, Your Honor, was that her understanding of what she was told was that it was fatty tissue and scar tissue, not that it was a possible tumor occurrence, not that it was possible cancer. That, to me, tells you that she didn't understand the importance of what she's dealing with. People act differently if you're told, I have cancer. You have cancer, go to the doctor, go get it taken care of, than if, you know what, I think it's...
Had she been diagnosed by cancer, with cancer at that point?
No, she had not.
No, exactly.
But
So
they
no one would have
suspected.
said to her, you have cancer, right? They would have said, as Dr. Shapiro did, here, go get these tests. And
I
she
disagree, Your
and
Honor.
she understood, well, she made the
Disagree very, very
appointments
much,
for
Your
the
Honor. I
test,
would
right?
expect, as I think you would expect, you go to a doctor, they think you have cancer, they suspect strongly you have cancer. You would expect them to say, We're hoping it's not this, but this is very important. This may be a recurrence of your cancer. We want you to go get checked out. That is relaying to the patient the importance of it. That is being a partner with your patient.
But that goes to the standard of care. And maybe there's an issue of fact with respect to the standard of care based on your expert's affidavit. But with respect to causation, I still haven't heard a satisfactory answer. Starting with, actually, we'll start with Dr. Shapiro. What more could a doctor have done at that point because your client didn't follow through with the tests?
Two very important things, Judge, and I'll start with the last. Follow up with the patient. She testifies. Dr. Shapiro testified that's part of her standard practice in these exact circumstances.
This is one time that the patient comes to the doctor, right? The client or the patient doesn't make another appointment with the doctor. What more is the doctor supposed to do under those circumstances?
Follow up when the doctor has not told her she thinks it's cancer, and she has that in her head. The patient doesn't follow up. Her practice is to follow up, which shows you the reasonableness of it.
Wait a second, you're saying that every doctor who tells the client, do these tests, and then doesn't hear from the client again, has the responsibility to go and find that client, find out whether that client got the test, and get the client back in, or ask the client, why haven't you come back in?
Absolutely not, Your Honor. Absolutely not.
But isn't
that
that
is
what
not
you're
the
saying?
suggestion I'm making. What
Is
I'm
that
saying,
not what happened here?
that is
She
exactly
did
what not
come
happened
back?
here, Judge. What happened here was a very specific thing.
Did the woman go back to her? Did the woman ever go back to Dr. Shapiro?
No, she did not.
Did she make the appointments for the tests?
No, she did not.
No, she did make the
Well,
appointment, she
excuse me,
canceled it.
Very, very good point. She made the
I didn't misread the record, just to let you
Fair
know.
enough.
She makes the appointments for the tests, and she doesn't go back to Dr. Shapiro.
And she doesn't follow through with the test.
Because
So
she
then
doesn't
I
think
just
she's doing
don't-
anything but going through a basic protocol. The doctor who has the knowledge of this risk in their head doesn't convey it to her. That is important. There's no.
Well, that's not accurate. That's not totally accurate, because I thought somewhere in the record that she, the plaintiff herself, knew the urgency of the situation.
Very good, Judge. That was one quote that was taken from her entire deposition first by the lower trial court and then by the defendants in their briefs, which said that she agreed. She was asked the question, do you feel a sense of urgency to follow up? And her response was, yes, I feel it. It was never developed as to why she felt urgency, whether she thought it was cancer or just because the doctor told her to go do it, whether there's any reason at all. And the contrary testimony, which there is an abundance of it, says very clearly that she never understood what the MRI report said, what the breast surgeon, she left the breast surgeon thinking, this is nothing. And everyone would react the same if you thought it was nothing as opposed to you thought it was cancer. If you think it's cancer, you do not react the same way as you would if you were told it's nothing.
So in other words, the doctor should have said, "Oh, it's cancer. Do something about it." When the diagnostic test hadn't.
Close,
to say
Judge.
that.
I think
So you're going to scare the patient.
They should have said, this is very concerning. We need you to follow up. And again, if you're going to hold that information, Judge, if you're going to hold that information to yourself and not convey it to the patient, then yes, you need to follow up.
She gave her prescriptions to get tests, correct?
Follow up with that,
said,
Judge.
follow
When you
up,
think
get
it's
these
cancer.
tests.
When you think it's cancer, follow up with it. Any other circumstance, I don't think they do have that job.
Okay.
When excuse me, do you say?
Thank you. You have rebuttal time. Thank you.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. Andrew Harrison from Garson and Jacob for defendant respondent Dr. Shapiro. The record in this case is clear. Plaintiff knew there was an urgency to completing the test that Dr. Shapiro ordered. Dr. Shapiro.
Refresh my memory. What did Dr. Shapiro say to her on that one single visit?
Dr. Shapiro did not have a distinct recollection of her visit with the patient, but she said that her custom and practice would have been to say, you need to have a PET scan. It needs to be done in short time, which would have been within 2 weeks. She would have said that to the patient. And she specifically recalled that she said that I'm ordering the PET scan to rule out cancer.
She wanted a full diagnostic run on her before she made any diagnosis to her. I mean, she just didn't want to tell her, oh, you got cancer. She wanted to make sure before she even said that for her to go through to get these tests, correct?
Right, that's correct.
Okay.
She wanted to make sure that she had the appropriate diagnostic tools at her disposal that she could review in order to make an accurate diagnosis.
And she expected that the plaintiff was going to make a follow-up appointment with her.
That was the custom and
That was
practice
never done.
at her office, yes.
That was never done.
That was never done.
So it sounds like your stronger argument is causation, but isn't there a case law in this department that generally issues with respect to causation should be decided by the jury. Why should we decide as a matter of law if we do?
So I believe that the trial court correctly determined that this was a proximate cause determination that could be made on the record in this case, because a patient losing health insurance and not following up with recommended diagnostic tests is not a natural and foreseeable consequence of an alleged failure to communicate the severity of a potential diagnosis.
And to that point, I think I read somewhere that she did in with another employer, that she could have obtained health insurance, but she declined to do so because it was too expensive.
That is correct. That is in the record as well.
Okay.
If there are no further questions, thank you, Your Honors.
May it please the court, my name is Ruby Ray. I'm from DOF PC, and we represent Dr. Rao, a physical rehab physician, and Mid-Hudson Comprehensive. The issue regarding our clients, Dr. Rao and Mid-Hudson, is for proximate cause. The plaintiff's expert alleges that due to the negligence of our clients, it deprived Marjorie of a physician to guide her in the proper evaluation of her condition. We argue that the plaintiff was not deprived of a physician because she was seen within 3 weeks by a breast surgeon who is the correct specialist to evaluate and determine her condition. The fact that she was given a prescription by our client as a favor, and the fact that she took that prescription and had no communication with my doctor regarding the result of that 2-page MRI.
And what, would she even have communication with your doctor? I mean, your doctor's specialty had nothing, obviously, to do with treating cancer, correct?
No, she was not a treating provider, but if she wanted to speak to my client, they worked together. The plaintiff was the office manager, and my client worked there, and they've been working together for a while. And the plaintiff obviously felt comfortable asking Dr. Rao for this favor to expedite since her getting an MRI, since she did not have insurance. I also wanted to point out that plaintiff's experts did not deal with the issue of proximate cause in the lower court, and I don't think he should be able to create issues of fact when he didn't address it by expert testimony, which is required.
Okay, thank you.
Good morning, Your Honors. Good afternoon, I'm sorry. My name is Stephanie Campbell. I'm from the law firm of Chiavetti, Corrigan, Edwards, Weinberg, and Nicholson, and we represent Dr. John Rigney and the Distinguished Diagnostics Imaging, which I'm just going to refer to as DDI. Plaintiff's expert, in opposition to our motion for summary judgment, said that it was the duty of Dr. Rigney to immediately report the findings of the MRI to the referring physician or the plaintiff, and that is exactly what he did.
He sent it to the fax at the office, correct?
Correct.
And it was picked up by the plaintiff, correct?
Correct. We know the fax was received because she admitted she took it off the fax machine, and also, if you see in the record, you can see on the top of the report.
But she also scheduled an appointment with Dr. Shapiro then, correct?
Well, she went to see Dr. Perez, and then Perez referred her to Dr. Shapiro. So she saw 2 other physicians after Dr. Rigney had sent the fax to Dr. Rao's office. And also, plaintiff said that when she went for the MRI itself, she said a doctor came out and told her that, you know, she needed to see another doctor, she needed follow-up. So therefore, based on even plaintiff's testimony, there's 3 doctors that have told her, you need follow-up. And she's the one that decided she didn't want to do the follow-up because she didn't have health insurance. So there's nothing else that our doctor could have said that would have changed the outcome of that, because by this time she has 3 doctors telling her that she needs follow-up. There's nothing more that Dr. Rigney would have said at that time because he doesn't know if it's cancer or not. Nobody knows at this point. All he knows is that something that's suspicious. He categorized it as a BI-RAD4, which he said in his testimony could be 2 to 95% cancer. So that's a huge range, obviously. So he doesn't know, even at this time, if it's cancer or not. He couldn't have said anything more definitive to her that would have pushed her over the edge, if you will, to take this other step to get the testing that she knows she needs. She also said that she read the report up until where it said impression. And right before it says impression, he says twice that she needs a biopsy. And she said that she understood the term biopsy means this is when you take the cancer, the tissue out to see where the cancer is. So she knows the word biopsy. She's had cancer before. So she can't say that she doesn't understand what's happening when she sees the word biopsy twice in the report by her own admission that she read up until that point of the report. She also has a history of cancer, and she also said she had this urgency. She knew there was this urgency. That's why she went to 2 physicians. That's why she went and picked up the films from DDI. So she's doing all these things, so she must know what's going on. And our position is that she did know what's going on. So not only did we do everything that was stated in plaintiff's expert affirmation as to the standard of care, we sent the report immediately, but there's no indication that she didn't understand what the report said at all. And notwithstanding the proximate cause that, that we've talked about, that, she saw these other physicians, there's nothing more that could have been done on behalf
And there
of
was
our
really, and there, in the timeline, if you look at the timeline, these all happened within a couple of months
Very
of each
quick.
other. I mean, we're talking pretty quick.
Sure, she saw Dr. Perez within a week. She saw Dr. Shapiro within 2 weeks after that. So we're talking about within a 3-week period. And then she gets the records with, I think, a few weeks after that. So everything's happening very quickly. It's just she did say that the reason that she didn't do any of the follow-up was because she didn't have insurance, and that's unfortunate. But that's came out being imputed to our client.
Thank you.
Thank you very much, Your Honors.
Your Honor, just in rebuttal briefly.
Yeah, counsel, will you address what you think diagnostic, what you've shown with respect to Dr. Rao and diagnostic?
With Dr.
Rao
was the physiatrist. Are you talking about the radiologist?
Yeah. No, the physiatrist.
And the question was, what the physiatrist?
Yeah, where's the evidence of proximate cause with respect to the physiatrist?
Yeah.
And the
Dr. Rigney, right?
Diagnostic,
Very good.
the reader.
Yes, Your Honors. Same idea and concept as before. The entire claim we're making is that they have failed to be a partner in this treatment plan with the patient.
Look, let's start with Rao.
Yes, Your Honor.
Oh, as counsel said, within 2 or 3 weeks, a series of doctors have seen your client or seen the decedent. What more could Dr. Rao have done?
As the initial referring doctor, I would expect a doctor to follow their patient and make sure they help manage the care, help make sure they go to the proper referrals, that she explains what those referrals are.
Wait, was Dr. Rao getting paid? Were they?
Dr. Rao made a bad decision, Your Honor, to make a physician-patient relationship with someone without having the structure in place to take care of it. And that was the exact problem, because she is then left on her own to go figure this out on her own.
I don't know. She's got 3 other doctors, 2 other doctors. She's definitely not left on her own.
But all we're talking about is she left worse than she was when she got there. Is she better off, or is she worse? And she's worse because now she's on a course of action of treatment where she has no one to guide her and explain it to her, no manager. And let me just...
No, after Dr. Rao, she went to see Dr. Rigney.
Yes, I was going to get that.
Yeah, you can't say that after seeing Dr. Rao that she was sort of left, wandering in the desert.
Well, she was,
The next
Judge.
game plan, 2 weeks later or a month later, she saw Dr. Rigney.
And Dr. Rigney conveys the results to Dr. Rao, which understandably plaintiff takes, but
she takes that,
I know,
she takes those results, so he doesn't even see it.
But the doctor still, as a doctor-patient relationship, still has a responsibility to follow up and get that record, right? She's the referring doctor. She should get that back. So she should talk to the client about, patient about it. But the point is, Dr. Rigney failed to communicate these very ominous results immediately to the patient, or call the doctor to make sure. What if it had gotten lost in the fact?
For that,
Lots of reasons why it doesn't get through.
Okay.
Yes.
To that point, after Dr. Rigney, she went to see Dr. Shapiro.
Yes.
So it's like at that point, you're now removing Dr. Rao from the scenario, because whatever alleged malpractice may have been committed by Dr. Rao, the fact of the matter is Dr. Rigney now has gotten her, the plaintiff, to go see Dr. Shapiro. So that right there, she's getting a follow-up care, of getting the follow-up diagnosis or follow-up treatment that she needs or whatever, right?
But it's not an intervening cause. It's just another substantial factor in the reasons why she never figured out that she probably had cancer. She never figured that out, and we know that because of her follow-up. So when Dr. Shapiro testifies...
But she didn't know she had cancer because she didn't go through the diagnostic steps because she didn't have insurance.
Well, no, more than that, Judge. Listen, this is the testimony. You asked me, one of your honors asked me before, the testimony from Dr. Shapiro about her appointment. She said this. She says that she did not explain or discuss the findings from the MRI report because she did not want to alarm people unnecessarily. And she conceded that she was not even sure the plaintiff understood her instructions at all. So how can we now sit here and say that she was given proper instructions, this was a good thing to do, and how could she not follow up when the doctor doesn't even know if she...
Wait a minute. The patient understood enough to have an appointment for a diagnostic and then didn't follow through. So it's not like the patient did not understand what was going on.
The patient didn't understand the severity, the significance. There's a very big difference, Judge. She understood basic instructions, go do this, this, and that, but in her mind, she's doing it because we're just going through the course of, I'm doing now another multiple imaging studies. I've done an ultrasound. I've done an MRI. I'm just going to keep doing them because they're sending me because they don't really know what to do with me. No one said to her and stressed to her, this could be cancer. Please make sure you follow up. And again, if you're going to hold that information, then it is your responsibility to reach out to the patient when they don't follow up and say, we need to at least tell you, you might have cancer.
Okay, thank you, counsel.
Thank you, Your Honors.
Silverman versus Silverman. We're waiting for Justice Kern to come back. Please get ready. Oh, you're back. Okay, never mind.
Good afternoon. May it please the court. My name is Heidi Talentire. I represent the appellant, Alexander Silverman. There are two matters before this court today. I understood from the court that I'm to do both of them simultaneously. I'll start with the custody appeal. The lower court incorrectly quashed appellant subpoenas directed to respondents' mental health providers, which was reversible error for the following reasons. 1, respondent waived any privilege for her mental health records in the following ways. She requested and received sole custody. Counsel, is the question really whether she waived the privileges? The question is what relevancy would these records have to what was being determined at the custody hearing? So, Your Honor, how are they relevant? So I think there's a two-prong factor here that the First Department has found previously. The one portion is, did she waive the privilege? And we argue that she did. The second portion is, what is the material, were the documents material and necessary? But the only way the court could determine that is through an in-camera review, which it did not do. And
what about the forensic report being sort of a gatekeeper in terms of determining that the mother's fitness to be a parent was not in question?
So I'm sorry, I missed the last piece that you just...
Does the forensic report obviate the need for an in-camera inspection of mental health records?
Absolutely not, because the forensic, it was not there as a mental health provider. The forensic did not receive the totality of the documents. In fact, they received redacted documents from Dr. Ochio Grasso and no documents from Dr. Diamond. Dr. Diamond had been the treating therapist for many, many years, and then unexpectedly and without explanation, Dr. Ochio Grasso was included as additional one.
Let's go back a minute, because the issue is whether these records would have been relevant in any way to a determination of custody. It's undisputed here that the father is not challenging the mother's capacity or ability to raise the children. And there's no evidence that she's in any way unfit to raise the children. Given those circumstances, what relevance would those records have to the issue of the determination of custody?
Sure, Your Honor. So they're twofold. The first is that this is not just about raising the children, this is also about decision-making, which is what sole custody
obviously
What would have
impacts.
come up in the psychiatric records which would show that she's unable to have decision-making as to the children? What's the argument?
So the first is that we don't know what we don't know, and the court doesn't know, and the court sits parens patrie over these children and the welfare of these children, and the First Department has found that where there's a request to review the mental health records, then in that circumstances, the court at a minimum has to review them in camera, and this court did not.
But you don't think it was
Second
incumbent,
factor-
I'm sorry, Counselor, you don't think it was incumbent on the husband at the hearing to raise issues with respect to the mother's therapy as it related to any of the custody issues?
So, Your Honor, he
Because
did.
had you done that, maybe some of those records may have come in. But if you didn't do it, why, as my colleague is saying, why, even if it was error by the court not to do it in camera inspection, why does it matter at this point? You didn't raise it, and that's the end.
Well, he did raise it because he raised it in his witness list, in which he stated, depending on how the motions to quash were ruled, there would be an addition of witnesses relating to the wife's mental health. In this circumstance, privilege was determined.
How can you make the argument when you're not making any argument that the court made the wrong decision or the decision was flawed in any way, or that, any way that the court erred? In that circumstance, how can the absence of the psychiatric records being admitted have any relevance to this case?
So again, this is a situation in which it's impossible to know if there was something in those records which would have reversed the court in how it was ruling. It's palpable, the amount of anger between these two parties. But again, that has bearing on whether or not a parent is able to foster a relationship with the other child.
Counsel,
There's
the word
mental
fishing
health
expedition
history.
just,
I'm sorry.
the word fishing expedition, or the phrase fishing expedition just comes to mind here. It's like you're looking for something to justify the obtaining these records. Did the husband ever ask that the mother undergo a psychiatric evaluation by his own expert?
No, Your Honor, that was in part what the forensic evaluation, which was done by the court itself, was to do. And that forensic relied on limited documentation.
He spoke with the wife, didn't he? The forensic evaluator, Dr. Aronson?
Dr. Aronson spoke with the wife, yes.
Okay.
But again, in reviewing the records, he only reviewed redacted documents from Dr. Ochiograsso.
So, counsel,
none
right,
from
the
Diamond.
first thing you do is you hire a psychiatrist and you have the mother interviewed, correct? Did you do that?
No, Your Honor, and the mother would not have to
raise
submit to such an
any
interview.
issue at trial as to her mental competency?
I'm sorry, was there an
As
issue?
to her her mental competency to be a successful parent.
Aside from the anger issues and the fact that there was more than 2 decades of therapy that had happened here, no, Your Honor.
Right. So,
In other words,
so based on the fact that these two parties are angry at each other, right? They've been married quite a long time. The husband's known the mother for quite a long time, never put in any evidence showing, and never raised the issue of any question that she was competent mentally to raise these children. He should get all of her treating doctor, psychiatrist information, is your view?
So again, it's a two.
Let me just ask you, is that your view?
So I disagree that he never brought it up. He brought up to Dr. Aronson that there was schizophrenia in the wife's family.
No.
That being said, with
I'm
respect
saying
to her,
to the judge, did he say there is an issue about her mental competency?
that's part of what the motion to quash dealt with. And the fact that
in the motion to quash, he said that here are some facts that show that there's an issue as to her mental competency?
No, what he said was,
that's
we don't know
exactly
enough.
right. He didn't raise it. That's exactly right. He didn't raise it. He wants those records, but he didn't raise it.
But even if this court determines that he shouldn't get the records, the court who sits parens patrie over these children has an obligation to look at those records in camera and never did.
But
So we
I don't
know
understand
what is-
that. You mean to say a court has to look at records that are not material and necessary to any of the issues in the hearing?
That's how the court determines if they are material and necessary, because
I disagree. It's incumbent upon you to raise an issue and then the court would then review the records.
It was raised because the subpoenas were issued, then the motion to quash came.
Okay, I'm going to let you address the other appeal on your rebuttal time, and if there's not enough time, I'll give you more time.
Okay, perfect.
I'll let you focus on it then. Let's hear from opposing counsel.
Good afternoon, Your Honors. My name is Nina Gross, Dobresh Michaels Gross, and I am the attorney for the plaintiff respondent in this matter. I assume I'll just address both appeals.
You should address, especially since you don't have any rebuttal time, you should address both appeals.
Exactly. So sitting here, what I would say, Your Honors, is that in both of these appeals, the central issue is this appellant's refusal to accept responsibility for the consequences of his behaviors and the consequences of his choices.
Because they're clearly separate legal
Absolutely.
issues, separate things we have to decide.
So with regard to the custody, let's be very clear. There was Judge Katz specifically adhered to federal rules and guidelines, state rules and guidelines, and the prior determinations of this appellate division when he quashed those subpoenas, because as Your Honors have fleshed out already, there was no allegation, nor was there ever an allegation that respondent suffers from any mental illness or deficiency. In fact, as Your Honor pointed out, Dr. Aronson, in the order of appointment, one of the things he is supposed to assess is the mental capacity and whether there are any issues with
He never expressed to the court that I'm missing documents. I need to see more documents.
Not only did he not, but he administered psychological testing to both of the parties. He spoke with my client's treating psychiatrist or psychologist. Now, why is my client in treatment? Which is, I find, the most offensive part of this appeal, that we would pathologize people who try to get help, and that is exactly what Your Honors, or the First Department has said in its decisions. We want to encourage custodial parents to get help. My client is a victim of domestic violence. She was subjected to coercive control as confirmed by not only multiple experts, but Judge Katz.
I'm going to interrupt you, because why don't you focus on the second appeal, which I actually think is a more difficult argument for you. So you might want to spend some more time focusing on that appeal, because it's a totally separate legal issue, obviously, than the first appeal.
So, the issue in the second appeal relates to this house that the parties own. They own it through an LLC. It is their largest marital asset. The appellant has repeatedly insisted in this litigation.
Isn't the problem, though, we're familiar with the record and the history, but there is case law out there that you can't use an offer on a house to determine what the value of that house is. And in fact, that's not how valuation is determined at an ultimate equitable distribution trial. You would never do it based on an offer. So wasn't that error for the court to set a value for the house based on an offer for it without having more evidentiary proof before it as to the value of the home?
Your Honor, matter of acquisition of real property by V111 of Marathon, which is 174 miscellaneous, second 800, 803, speaks about an offer made by a private party may be admissible when it is made in good faith within a reasonable time and with the intention and ability to carry out the transaction.
So you're saying it's okay for matrimonial judges to decide the value of property is based on an offer someone makes on it,
No, Your Honor.
That's an acceptable practice?
I'm saying
Because that's in effect what he did. He said, I'm going to say that this is the value of the property. It can't be any lower than this based on an offer. So he made a determination as to value based on one offer on the property.
Well, but Your Honor, it wasn't based on one offer. So what I am saying is that what should not be permitted is for a litigant who is scheming and trying to buy this property out at a deflated value to refuse a bona fide contract, refuse to sign. That's what happened.
So, but counsel, is the solution to that the trial judge, without hearing any evidence and without making any real factual determination, saying, okay, fine, you can't sell the house for less than $20 million?
No.
That's exactly what happened here.
I don't think he said that you can't sell it. I think
the minimum value of the house at the trial, without having a hearing, without without really making any evidentiary findings as to, didn't hear any, I mean, he looked at some documents, but you think that that's the way to resolve this? Or is it better to save it for trial and have everybody put it on? And if your theory is correct, that the husband was trying to depress the house, couldn't you put that on as
Yes, Your Honor, I don't
evidence of
think
that? So why set a value now?
Because, Your Honor, what I think has happened here is that we have this house that cost these parties a tremendous amount of money to keep, not to mention the fact that because of the dynamic between them, appellant's refusal to sell it forces my client to spend a crazy amount of money
Right, but the
and
court,
to share it with him.
could have made the decision, I don't know if what we would have decided if that was appealed before us. The court could have made the decision, I'm going to order the house be sold now, but that's not the appeal we have before us now. The appeal we have before us for having any formal hearing and hearing from appraisers as to the value of the property. The court basically set a value for the property.
What the court said, was that in light of appellant's utter refusal to sign this bona fide this contract that the purchasers had signed, they gave an offer, and let's remember, appellant's position was that this house is only worth $9.6 million, and he's offered $20 million. At the same time as he is not paying child support, at the same time as he's claiming he no longer makes millions of dollars a year and only makes $100,000 a year. All Judge Katz said was, I am going to hold you responsible for the consequences of your decisions. So he can make this choice. If he's rejecting the offer...
I think the point that we're trying to make is, shouldn't that be done at trial where there is proper evidence as opposed to
I think
accepting at face value what is occurring now?
I think the other thing that's an issue, Your Honors, is that due to no fault of the court system or Judge Katz, whenever this financial trial is going to happen, it's not happening for years from now. So here I have a client who can't sell this house due to case law from 1977. We can't sell the house during the pendency. We have an appellant who refuses to rent it out. They've been offered $1 million for the summer. The children aren't even here.
Well, then that's the application you bring, but okay, thank you very much.
Thank you.
You have rebuttal time.
With respect to the Southampton house, the lower court improperly assigned a minimum value to the home, which was held by an LLC. And the timing, as the court was just mentioning, is not correct because it should be after a hearing, after a trial, and pursuant to the distribution of the entirety of the
Why can't the court consider your client's actions in terms of not refusing to sell the property, refusing to rent the property? Can those be considered?
The court can consider those at the time of trial. It's improper to basically decide on a summary judgment in effect without it being called a summary judgment where the facts are in dispute. My client has an appraisal from the beginning of the case on this, which was half this value. My client disputes whether or not
when was that
even
appraisal?
a real
I'm sorry,
offer.
when was that appraisal?
I'm sorry?
When was that appraisal received?
When was the appraisal received? In 2019, I believe.
Okay, so you wouldn't think that the properties have changed values over the last few years?
Absolutely, absolutely. But then that would be, there should be another valuation that's through an appraisal, not through an offer. As this court accurately stated, there's case law that states that an offer is not accurate evidence of value if this was even a bona fide offer.
Counsel,
which
is your client paying any of the carrying costs for the house?
So yes, there is an account which has the refunds from taxes, which are in the millions of dollars, which are undisputedly marital, and those funds have been ordered by the court to be used to pay the carrying cost of the house.
Okay.
And there's millions of dollars in marital property that's sitting in the wife's sole name in addition to that.
Thank you very much.
Thank you.
Nicholson versus Saby.
May it please the court, my name is Scott Singer, and I represent the plaintiff appellant respondent in this matter, and I'll be addressing both our appeal and the cross appeal that we're responding to that was filed on behalf of defendant Sabi. Our own appeal couldn't be more discreet or straightforward. It concerns a single regulation, Industrial Code Section 23-1.7E, which prohibits tripping hazards in construction site passageways and working areas. In the present case, there was undisputed proof that there was a tripping hazard, specifically 4 or 5 loose pipes on the floor of a passageway just a few feet from where the plaintiff was standing when he was unloading the pallet. When the pallet jumped back, plaintiff jumped back too, but his way was blocked by the pipes on the floor, and he ended up falling on the floor, and the pallet jack landed on top of him. Now, Section 23-1.7 prohibits scattered tools and materials in working areas.
Counsel,
Go ahead.
do the Sabi defendants or ADCO even address the applicability of that particular industrial code regulation?
Sabi didn't address it in its principal brief.
Yeah.
They did put a sentence in, I checked in reply to plaintiff's motion papers. Essentially, the court said, well,
Isn't the issue just a passageway, and the court looked at the main passageway, but you're saying it was another passageway?
Right.
And that's how you believe the court erred in dismissing that?
Yes, that's it. And the industrial code is very clear. It says all passageways are supposed to be kept free. It doesn't say the passageway you're walking on. So in this case, there was a nearby perpendicular passageway that had the debris, or they had it was actually pipes. I don't know if you could call it debris or not. So we believe that the passage, it was clearly a passageway. It's also a working area because it was only a few feet away from where.
Yeah, isn't that, actually, I'm just thinking, I'm wondering, isn't that finding that the court ruled against you with respect to that 23-1.7E, is that kind of inconsistent with its finding on 23-2.1A1, right? I mean,
I was thinking the same thing
it's kind
myself.
It struck me as ours.
Yeah.
One that says, it's blocked. The other one says it wasn't blocked. And I'm like, well, which is it?
Yeah, 2.1A is a little bit different language. It talks about walkways and passageways. But there's no dispute that there was a passageway.
Yeah, conceptually it's the same because one he says there was blockage, and then one he says there is no blockage. I was kind of like, which way is it going?
Right, yeah, I didn't think it made a whole bunch of sense. And I think that regardless, it was in a passageway, even if it wasn't the passage, it was not the passageway he had been working on, but it was close by. The regulation was violated.
There's an issue with respect to what pipes your client fell on, correct?
Well, I don't know.
Your guy says black pipes. Your guy says he fell on black pipes, or a black pipe, not an electrical pipe.
You know what, I don't think anybody knew for certain where the pipes came from or could describe them more fully, but there were 4 or 5 pipes on the floor, according to the plaintiff, and there was also a stack of these pipes in the immediate area. So that stack wasn't stable. So the only other issues that are raised are Labor Law Section 200, and there were a couple of other regulations, 1.5 and 9.2, 23.1.5 and 9.2, which the defendants contend are not applicable, although the court said that they were applicable to the case. They concern the repair of the pallet jack. And in this case, there were complaints made by the plaintiff to his foreman about the condition of the pallet jack. And despite those complaints, the equipment was not repaired, and there's no evidence that any inspections were conducted of those. So we believe that the court correctly decided that 1.5C and 9.2 were violated. So we think all 4 regulations were implicated. Questions of fact as to all of them, and we just want to proceed to trial on those violations. 200 I'll deal with on my rebuttal time if the court has any questions. Thank you.
Good afternoon, Your Honors. May it please the court. My name is Lisa Fitzgerald with the firm Weber Gallagher, and I represent the Sabi defendants in this case. As an initial matter, I'd like to address the third-party complaint and the third-party motions. it appeared that the lower court.
Don't a lot of the issues tie back, though, to whether or not you were negligent, or whether it's a question of fact as to whether you were negligent, because that affects a lot of the indemnification claims and how they would get resolved.
Well, that does, but ADCO's motion, for example, was improperly denied, as I addressed in my papers. It appeared that the lower court failed to consider any evidence that implicated ADCO in this case, or their materials, including their pipes in particular.
Well, didn't Mr.
The court was very clear about ADCO, but go ahead, I'm sorry.
Well, I was just going to say, Mr. Assini from ADCO said, no, we don't have black pipes, that's one thing. He said, we don't keep our pipes in the storage room, and we rarely kept anything in that storage room. I mean, why isn't that enough to let them out?
Respectfully, Your Honor, Mr. Assini testified that they only use silver pipe. However, he also testified that they sometimes store pipe in the storage room, as well as other equipment.
But unpiped trees, right? Unpiped trees rather than in stacks. I think he categorically said not stacking.
Well,
Am I wrong?
No, he testified that they stored pipe trees on the third floor, I believe. But my understanding of his testimony was that they sometimes, but rarely, stored pipe in the storage room. So what I'm saying is there's a question of fact as to whether or not it's their pipe. And Your Honor, respectfully, the plaintiff himself just knew it was metal pipe. He didn't know if it was black or silver.
Testify that these are not the type of pipes electricians use. The plaintiff himself testified that.
Respectfully, Your Honor, the testimony of the plaintiff was different at different times. He actually did testify that this could have been electrician's pipe. Again, we have questions of fact here. It could have been electrician's pipe. It could have been silver.
Your guy, Price, would have been able to resolve this, right? Because he wasn't even there, and he would have been able to tell us what pipes, whose pipes they were. But he didn't even do that, right? He changed his testimony a little bit, didn't he? Mr. Price, Mr. Mark Price, isn't he your representative?
Correct. Mr. Price was the superintendent for SABE.
Right. So
he came to the accident site after learning about it.
Right.
He witnesses 4 to 5 silver pipes off of their stack, which were involved in the incident. They were in ADCO's area.
Let me interrupt for a second, because ADCO clearly testified that it used silver pipes, and the plaintiff clearly testified they were black pipes. Isn't that immediately enough to get ADCO out? In fact, they were different pipes and different sizes than what plaintiff testified they were.
No, Your Honor, it doesn't, because there was other testimony that plaintiff said that it was metal pipe. It could have been black. And when
can you cite the record to that testimony?
Because at record page 392, plaintiff says the pipe was black, 6 inches
I didn't know. I
wide,
didn't
5 feet
see
long.
what you're saying.
No, certainly the plaintiff testified that the pipe was metal pipe.
And is
Right, and theirs was silver, so
Silver,
isn't that enough to get them out?
and not the type of pipes that the ADCO people used. I mean, he testified to that.
He testified it could also have been an electrician's pipe. He also testified that it may have been a black pipe. He also said it could have been
Can
white
you tell us where you think he testified to that? Because I didn't see it. That's why I'm asking you.
Sure. The pipe in the area where plaintiff's accident occurred
Can
was.
you just cite me to the record? Because I didn't see it, and if you did, I'd like you to just tell me where.
Sure.
You know, if you want, you can do
Your
that.
Honor, I'd like to take a look at that on my.
I was going
yes,
to say, you can
rebuttal.
let us know in rebuttal what you're referring to.
If I may, I will. If I may, just address a few of the other claims.
Can you address the 200 claim, please?
Sure, Your Honor. As we know, Labor Law 200 addresses either dangerous condition or means and method.
Oh, is this a means and methods?
No, it is not, Your Honor.
Didn't
trial
Price,
judge
I'm sorry, didn't Price testify that he directed the subs where to place their equipment?
He did. Where to place them, not how to place them. So if you're telling someone, an electrician, you're going to go work on the third floor, but if you're not telling him or her how to run conduit, for example, that's means and methods.
Boy, you're slicing and dicing it pretty fine, aren't you?
respectfully, I don't think I am. I think in terms of having general supervision, as SABE did, they're not going to be implicated under Labor Law 200. There was also no notice of a dangerous condition. Mr. Price did a walkthrough about an hour before the accident, did not see any loose pipes. They were never notified of any issue with the pallet jack. The plaintiff doesn't even allege that in his papers, that there was that 200 is implicated because of the pallet jack.
Any more questions before we go on? Okay, thank you very much.
Thank you.
Good afternoon. May it please the court, Joseph K. Strang for the respondent, ADCO. I sense from
Where were your pipes? Were your pipes in the passageway area?
No, sir. The testimony from ADCO is that their silver conduit, upon delivery, is taken from the loading bay, placed directly onto a pipe tree, and brought to the place of work on the 3rd floor. The storeroom for ADCO was utilized for this temporary storage of large things, transformers. Basically, I'll use a simplistic definition for the type of equipment that was placed in the storeroom.
Counsel, do you ever recall your plaintiff saying that ADCO's pipes were on the 2nd floor?
No, Your Honor.
Is there anything that you remember in the record where the plaintiff might have said that?
I cannot recall any testimony to that effect, Your Honor, and I think that what is clear from the record is that Mr. Price did not see the occurrence. He comes to the scene perhaps within an hour afterward.
And doesn't he see 4 or 5 white silver conduit pipes?
Correct, Judge.
And he said that at his second EBT, right?
Judge, in fairness, I think in the first deposition he said he saw silver electrical conduit, but he didn't know who it belonged to. In the second deposition, he has some revelation and now attributes ownership to ADCO. But the fact of the matter is that the only person who knows which pipes were involved were the plaintiff himself, and as Your Honors have pointed out in your own inquiries, Mr. Nicholson is crystal clear. The pipe that he was pinned against was black, 6-inch, 5-foot-long pipe of the type used by plumbers and steam fitters, not silver electrical conduit used by electricians.
So even if it were there, it didn't matter. Right? Essentially that's what they argue. It's like it really doesn't matter. You know, that's not what caused his injury.
And Judge, also I'm prompted to recall something that the lower court said in the opinion. To his perception, the presence of those pipes was not the real proximate cause of the accident. It was this defective pallet jack which jumped into reverse and pinned the man. If those pipes weren't there, he would have been pinned against a wall, against a pallet, against something else. In the perception of the lower court, I don't think the presence of those pipes were really relevant to the outcome. If you have any other questions, I would be pleased to answer them, and otherwise I'll rely on the brief. Thank you very much.
Thank you.
Good afternoon, Your Honors. May it please the court, Thomas Maroney for respondent and third-party defendant, Select Safety Consulting Services. We're asking the court to search the record and dismiss all claims for contractual indemnification, contribution, common law
Did you
indemnification.
move below?
Excuse me?
Did you move below at all?
We've taken over this case from prior counsel, and prior counsel sought a dismissal on negligence claims and not on contractual indemnification. However, they did raise...
There was never any motion by the court below by Select Safety.
They raised it in their reply. In the alternative to the search of the record and dismissal of the claims, we'd ask that you uphold the decision of the lower court. And
But why should we search the record? Go ahead.
we think you should search the record because it's clear in Sabe's papers that there's no proof of negligence or active negligence on by Select Safety. The 2,000-page record and all the briefs that you've read contain no evidence that Select Safety acted negligently. The contract has a negligence trigger, and the contract does not require Select Safety to direct or supervise or control or permit them to supervise or control the work of the plaintiff or any of the trades on site, any of the subcontractors. They had no authority pursuant to the contract to stop work. They had no authority pursuant to the contract to control the means and methods of the work.
Did your client have anything to do with the placement of pipes that we've been talking about ad nauseum?
Specifically, Mark Price's testimony over and over, he takes ownership of where the pipes should be and where they should be placed, and he never allows Select Safety, pursuant to his testimony, that right or opportunity to do so. Their only duty was to walk the site 3 times a day, which they've met that burden pursuant to Mark Price's testimony that he walked the site 8 to 10 times daily, was walking the site.
What duty of inquiry did they have, if any? In other words, walking the site is one thing, observing something with your own 5 senses, but should they have spoken to the workers? And had they spoken to this plaintiff, maybe they would have found out he was having a hard time with this pallet machine.
With regard to the pallet jack specifically, they had no duty. The duty with regard to maintaining pallet jacks or power-operated machinery on site pursuant to the subcontracts between SABE and every subcontractor was burdened onto the subcontractor individually. They were to report any maintenance issues directly to SABE, and directly in Mark Price's testimony, he testified that those reports would never make their way to Select Safety, and they would be rectified by SABE on their own.
But I mean, you never made that argument to the trial court, so, and none of the other parties ever had an ability to defend against it, right?
The underlying papers in the trial court, they presented arguments.
Well, because they argue what everybody else argues. But now you're asking us to grant you judgment on an argument that you never made, and the other people never had an opportunity to respond to.
Absolutely, Your Honor, and I agree with that position, and I think that we are asking in the interest of judicial economy to search the record, whereas we would expect to make this motion eliminate at the time of trial and cost both our clients, their clients, and everyone involved in the courts.
Can you finish Justice Moulton's other point of his other question about what other duty you have when you're walking around? What, if you see optically something, what do you do?
Sure. If they're walking the site in their 3 days, in their 3 walkthroughs throughout the day, and they notice something improper, their duty pursuant to the contract, which is vague, is to inform SABE of the issue or inform directly the subcontractor of the issue and have them rectify it on their own. They're not there to stop work or control.
Nothing for you directly to do. You had to tell somebody else.
Correct. That is correct. Also, a case that was recently decided by this court, Harris versus the City of New York, in February of this year, had a similar mirroring set of facts where the plaintiff tripped and fell over a temporary barricade. The site safety company, there was claims against the site safety company for contractual indemnification, contribution, and they were all dismissed by this court because they found that the site safety company had no duty to control or supervise the work of the plaintiff, and they did not control the means and methods of the work, and they met their burden pursuant to the contract and controlled the site and walked it 3 times daily. It's the same case that we have here and the same set of facts, and we're asking that this court search the record and make a determination that none of these contractual claims or claims of common law indemnification contribution should stand.
Thank you.
Thank you.
Your Honors, just to clarify this question of whether the pipes caused the accident, plaintiff's testimony was that the pipes were what prevented him from escaping from the falling pallet jack, so they were clearly a cause of the.
Can you address Saba's 200 argument saying that this is, well, I guess it's just a means and methods, and they don't have control, although Price directed the subs where to put the pipes?
Yeah, thank you, Justice Singh. I was going to do that. This is Mr. Price's testimony. And you would supervise and direct subcontractors to specific areas where their materials could be stored. And this is, I'm reading from page 855 of the record. Correct, Price answers. And when you gave that supervision and direction to them, were there any safety instructions that went along with them? Answer, they were required to keep it a minimum of 8 feet wide aisle, of an 8 feet wide aisle. Then later on, and he says, at times during the, Price continues, at times during the project on certain floors it became limited, and at that time they would move their storage to another floor that was not limited. And then he goes on and he says, if there was stuff, the material that was outside of the storage area, he would direct them to correct that situation as well. So they had basically complete control over the usage as well as the placement of those materials. Yeah, I think this is the rare case where there actually is control over means and methods. And that's a basis for liability under 200, as well as the dangerous condition liability. So if there are no further...
There's dangerous condition. What's a dangerous condition and what's notice here?
The dangerous condition is the presence
Scattered
of pipes
pipes.
on the floor.
Scattered pipes. But what notice does Saba have of the pipes? Didn't Price say that he walked through it earlier, an hour before, or something like that? And there
He
was
said
nothing?
that, but there were plenty of other people that were there. The laborers were in the area. Select Safety was in the area. There were other people that were there. We didn't really hear from them. So we don't think that they established, as a matter of law, that they lacked notice.
Thank you very much.
Thank you very much, Your Honors.
Counsel, let me just start with asking you about Select Safety's request that we search the record. And what's your position on that?
Simply put, CPLR 3212B and the case law of this department does not permit that. They were not a non-moving party at the time of summary judgment. They made a summary judgment motion. The parties opposed it. They had time to reply. SABE certainly did not oppose the motion that they would have made if they made it. So
Well, that's what I'm trying to figure out. You're saying I have arguments against Select Safety that I didn't make, or are you just like, you're hanging your hat on the procedural issue?
No, there were arguments that I would have made had they made them in their brief. But if my underlying papers show that they didn't move to dismiss a third-party complaint, there's really not too much to say here. So frankly, yes, unfortunately for them for making the wrong motion, this court cannot overturn the lower court's ruling.
What, do you have any, you said that's the law. Do you have a case that says that you can't search the record if they didn't move below?
Well,
I know you stated that's the law, but do you have an actual cite to a case that states that?
the case that Select Safety cited was Merritt Hill Vineyards, Inc. versus Windy Heights Vineyard, Inc. 61 New York 2D 106, 1984, which is a Court of Appeals case. And in that case, the court can search the record if a non-moving...
case that says you can't, that we don't have the power to search the record if they didn't move below?
No, Your Honor, I don't have a...
I didn't think that's the law. That's why I'm asking you, since you said it, if that's the law. I thought we do have the authority. That's why I'm asking you if there's a case that says we don't have the authority.
My understanding is that you would have the authority to search the record if they had not moved for summary judgment. But they moved. They just made the wrong motion.
But what's the authority for what you're saying?
The CPLR and the Merritt Hill case that was cited.
Okay, thank you very much.
If I just...
No, your time's up. Thanks.
All right, thank you.
We got everything.
Thank you, too.
Don't waste a minute.